without at least addressing somewhat the current situation and what's going on. So I'll start with some financial planning considerations. And then Tiffany and I will both make a couple points on the Secure Act and the CARES Act. And then Tiffany will get into her estate planning overview. And some of the plan giving points will be interspersed throughout the presentation. So I'll start with some of the financial planning considerations. We're not going to get into specific recommendations here. I don't have a crystal ball, and even if I did, advice would still need to be tailored to each of your unique concerns and considerations. I will say that we are not right now anxious to put money in the markets. It's just too much of a disconnect that 1 in 5 Americans have filed for unemployment, but the S&P 500 is still actually just a bit higher than it was this time last year. At least it was last time I checked. And it's going to be difficult to get things moving again. Even the longer this goes on, the harder it's going to be, even with the government playing a major role. And I'm going to read a quote from Niall Ferguson. I think it's a great analogy here. He says, and he's talking about specifically, I got this from his blog post specifically about this situation. You cannot stimulate a lockdown economy any more than you can accelerate in a car with 2 missing wheels. All you can do is stealthily employ policies that were once dismissed as too radical and hope that people and businesses will stay afloat long enough to resume normal service when the public health emergency is over, whenever that may be. So, you know, a lot of people are referring to what the government, the cash infusions as government stimulus, but I think he makes a really good point that it's not really stimulating. It's just sort of trying to keep it going. So we don't know how this is going to play out. But for people with a long-term horizons, panicking and selling when we have a correction is generally not a good idea. When markets do recover, they have a tendency to come back really quickly. There'll be a huge upswing in just a day or two, as we've seen recently. And if you're out of the market on those days, if you've panicked a couple days before and you're out of the market on those days, it's really hard to recoup those losses. So try to avoid panicking and selling when things are down. Ideally, the best way to handle it is, as markets are reaching highs, you want to shift your portfolio maybe a little bit more conservative, so that when we do have a correction, you've got some room to take advantage of better pricing. And then you can move to a more aggressive stance. And I don't mean go into all cash when markets are at their highs because you're nervous, because as we've seen, they can just continue to go higher and higher than we thought possible. But if you just scale back a little bit, it gives you some leverage to play with when we do have a correction, so that you can see a correction as an opportunity instead of something that's going to hit your portfolio too hard. Now, if you need cash from your portfolio to help cover living expenses, that's a different story. Ideally, in a worst case scenario, you've got steady income, whether it's if you're in retirement, it's bond interest, pension or Social Security income, or income from a rental maybe, and perhaps some bonds due coming periodically, so you aren't forced to sell assets when they're down to pay living expenses. You should know in advance where the cash you need to support yourself is coming from. I would say like 6 to 12 months at least. And one possibility is turning on Social Security sooner than you'd planned. That may be preferable to selling assets when they're down. I don't know that I'd take it before full retirement age, but that is something I've been talking with some of my clients about. They're worried they don't want to have to sell assets when they're down. I think, at any rate, that's a possibility. The same would be true for starting up pension and annuity payments. That's a possibility. So we'll move on. So that was not the most uplifting discussion, so I've thrown in a picture of some lab puppies to give you all a little break. It's pretty hard to look at those guys and not smile at least a little bit. So, and in keeping with the more positive vein, I'm going to talk about some options and some opportunities that the current situation provides. So there's I'm not sure I'd call it a silver lining, but if you're in a position to take advantage of this, that can be a good thing. Making Roth contributions or even doing conversions and paying the taxes now, if you're in a fairly low bracket, that can make sense if you're purchasing significantly depressed assets in that Roth account, because the Roth assets are not, the growth on those assets aren't taxed at all. It's not just tax deferred, it's completely tax free. So if you move some money into a Roth and purchase depressed assets, and then they come back really quickly, or even if it takes a while for them to come back, but you still get all that growth tax free, which can be pretty nice to have in retirement, all that tax free money. And as I mentioned before, if your portfolio is a little more conservative, maybe than you normally have it, you can use a downturn to shift to a slightly more aggressive portfolio when there's a correction. What I would say is don't sit there, set a specific point at which you're comfortable doing that and then do it. Don't second guess it. Don't keep rethinking it. Just do it. But again, not if you need that cash anytime soon. So as long as you're not going to be touching it for a while, that should be fine. And lastly, doing a financial plan and really understanding what your situation is in that worst case scenario. That can be really very reassuring. Even if your worst case is not what you dreamed of for retirement, maybe knowing what that is, that worst case, and knowing that it is something that would be acceptable can, it can help you sleep at night if you just have that reassurance that, okay, it's not exactly what I wanted, but I could live with it. And honestly, getting sleep right now is probably one of the best things you can be doing for yourself. So that's one of the things that I think planning can really help with. There are some additional opportunities provided by the Secure Act. Now, this is not to be confused with the recent CARES Act. This doesn't have anything to do with COVID. This passed last fall and took effect January 1st. Now, prior to the passage of the Secure Act, required minimum distributions from your retirement accounts had to be taken at age 70 and a half. It's now age 72. And presumably that reflects the fact that was passed because people are working longer and living longer, so they're just sort of shifting everything out a bit. Individuals can now contribute to IRAs past 70 and a half. That was always possible with 401ks, but this is new for IRAs. So if you're working and you still haven't earned income, you can be contributing to an IRA past 70 and a half. However, if you're making qualified charitable distributions, check with your advisor or an accountant because there are some qualifications for that. And if you're not sure what a qualified charitable distribution is, it's also shortened as known as a QCD. That allows you to make a donation to a qualified charity, a 501c3 charity, but that's what most charities and churches and the library foundations are 501c3s. So you make that charitable contribution directly from your IRA account to the charity, and you don't have to recognize that as income, but it counts towards your required minimum distribution. So for example, you can take a distribution from your IRA, have the check made out. So let's say you have an IRA at Schwab, you have the Schwab make the check out to the King County Library Foundation, and the check can be mailed to you, you mail it in, but it has to be made out to the Library Foundation, not you. And you don't have to recognize that distribution as income. You don't get to take a deduction, but you never recognized it as income. And that can be as much as $100,000. You can do that up to $100,000. That can be particularly beneficial for people who don't itemize with the higher standard deduction that was put in place with the Tax Cuts and Jobs Act, the TCJA. That meant that a lot of people no longer itemize. So being able to make that qualified charitable distribution is a great way to save on taxes and support your favorite charities like the Library Foundation. And that deduction is for this year, it's inflation adjusted. Individuals, it's $12,400, and for couples, it's $24,800. And again, there are some technical things you want to be careful not to mess up, so that you don't mess up the gift and end up having to pay taxes. So just be sure you check with your advisor or your accountant or the custodian of your IRA account. One impact of the Secure Act that's generally seen as negative is the stretch provision for non-spousal IRAs has been eliminated. Now, prior to this act taking effect, if you left your IRA, for example, to your children, if you had 2 kids and you split it between the 2 of them and named each of them as 50% beneficiaries, they had several options for liquidating, and that included taking distributions over their life expectancy. So the RMD, your required minimum distribution, is calculated. You take the value in the account on December 31st of the prior year. So your RMD for this year would be based on December 31, 2019. And you divide that by your life expectancy according to the IRS table. So the younger you are, the greater your life expectancy, the greater that denominator, and the smaller the distribution. So the account lasts longer and you have to pay less in taxes because you're getting smaller distributions each year. And you're leaving more money to grow in the account. That is for non-spousal beneficiaries. That is no longer possible with the passage of the Secure Act. And this is for non-spousal beneficiaries and for decedents, people who passed away on January 1st of this year or later. So if somebody died last year and you're still settling the estate, you still can do that, the stretch IRA over your life expectancy. This stretch provision, the removal of this stretch provision, means that IRAs can be an even better gift to leave to charity because the charity doesn't have to pay any taxes at all. If you leave it to your heirs now, a non-spousal heir has to take that distribution within 10 years. Now they can take a little bit each year for 10 years, they can take it all up front, they can take it all at the end, but they have to take it and they're gonna have to pay taxes on that as income. And if you leave that to charity, or a portion of that, you don't have to leave the whole thing, but the portion that you leave to charity is completely tax-free. The charities don't have to pay taxes because they're tax-free entities. So those are great. That makes an IRA an even better option to leave. There are also some planning options that involve trusts that address the removal of this stretch provision. And Tiffany's going to talk about that, and then we'll talk on the CARES Act just a bit.
Okay, thank you, Catherine. One thing that I wanted to mention is I think we had some more friends join us while Catherine was speaking, and just wanted to apologize. Previously, we had sent out an invite that the platform was going to be Microsoft Teams, but when we migrated to using Zoom to ensure that everybody could join us, because there were a number of people who wanted to join. And so we have, I think, had several folks join in the last 5 or 10 minutes. And so just wanted to welcome you to the presentation and thank you for joining us. So as Catherine was talking about regarding the RMDs, the required minimum distributions, and the stretch provisions that were historically rules that we followed, and where this kind of comes into play in an estate plan, in one way rather, is related to some trust planning. Historically, folks have often looked at their IRAs as their retirement accounts as more of a wealth transfer tool for family members, for heirs, for organizations, versus a way to entirely fund retirement, or kind of a combination of those things. And with the passage of the Secure Act and the changes there, what this has really kind of done in the world of retirement accounts is it's sort of narrowed our ability to use them so much as a wealth transfer tool to more of a retirement planning tool. Now, you can still use them as a wealth transfer tool. And you want to look at kind of the big picture in terms of what all of your global assets look like as you're kind of putting together the pieces of the puzzle for both yourself, during life, and then for potential beneficiaries after you're gone. And in doing so, as Catherine mentioned, depending on the makeup of the assets, this IRAs have always been an attractive tool for charities, but I think that the passage of the Secure Act, if you are charitably inclined, this is even makes it more of an important note that this can be a really good tool for transferring wealth to charitable organizations. A couple things to think about in terms of kind of the trust planning piece are, as Catherine mentioned, now that with the changes, this other than a lifetime beneficiary in a spouse, a surviving spouse, there's very few individuals that are beneficiaries that can take advantage of that stretch provision. There's some special provisions for disabled or chronically ill beneficiaries, but the big key here is for minor children, which oftentimes folks include their children as beneficiaries on their IRAs, particularly minor children. And for minors, they have the 10-year period begins at the moment that they turn 18. So, say that the child is 15 when they become the beneficiary, that 10-year period for the full distribution of the account begins at 3 years later at the 18-year age mark, and then goes from there. So you're still in a position of only having until that person is age 28 to make the entire complete distributions of that account. And oftentimes these can be bigger assets for folks, and they say, you know what, I might not want my 18-year-old, 19-year-old, up through 28-year-old having access to all these funds. And so one of the things that it's important to weigh is not letting the tax tail wag the dog, as I like to say sometimes, but thinking about balancing the benefit of ensuring that the potential beneficiary is protected from themselves and others, and balancing that with the income tax effect of having using a trust for distributions to that minor beneficiary or young person or whomever in your life you're thinking might make sense. A trust might make sense for them. And there are two different types that we will look at in that vein, and that's the conduit trust, where the trustee is required to immediately distribute that retirement plan to the individual beneficiary. The other one is the accumulation trust, and that one is the difference there being that the trustee may accumulate retirement plan distributions in the trust. And why I say that you want to look at the income tax benefit is, as many of you may know, trusts have a compressed income tax bracket, so to speak. Whereas as individuals, we have a little bit more leeway before we top out at the top tax bracket. Trusts get to 37% income tax as soon as they generate a little over $12,000 in income. And so looking at kind of that issue as kind of, again, balancing the taxation, the income taxation of that asset, as opposed to kind of having some additional time for distributions to go out to that beneficiary or for the benefit of that beneficiary beyond the 10-year window that the new statute provides. The other time to consider this, where it might make sense or at least be worth weighing, is if you have a surviving spouse, but you have maybe children from a prior marriage and are trying to plan for your entire family unit, both your surviving spouse and subsequently your children from prior relationship. Again, wanting to weigh kind of the importance of kind of including everyone as beneficiaries and kind of mapping out a plan that works for your family versus kind of the income tax benefit. And then finally, the other, and this is an important exception involving the accumulation trust is when you have a disabled or chronically ill beneficiary, and particularly if you are, if that person's receiving certain government benefits where a special needs trust might be warranted, the kind of accumulation of income from the retirement account is an important consideration there, and that that's dependent on the type of language that's used in that trust. So again, conduit trusts, trustee can or is required to make out all distributions immediately over the course of that 10-year period. Accumulation trusts allow the trustee to hold some of the retirement plan distributions inside the trust for a more appropriate distribution scheme. And so with that, I'm going to hand it back over to Catherine to talk about the CARES Act, which is the other new piece of legislation that you've probably been hearing about.
Great, thanks, Tiffany. Yeah, the CARES Act is the CARES stands for the Coronavirus Aid, Relief, and Economic Security Act. That was passed and took effect immediately on March 27th. It's extremely broad. There's 7 titles to it. There are headings like keeping American workers paid and employed. Another title is supporting America's healthcare system in the fight against the coronavirus. And then the last title 7 is the always nebulous and miscellaneous provisions. So we're going to focus today on just a few aspects that may affect you as individuals. So as you may remember, I mentioned the TCJA, the Tax Cuts and Jobs Act, increased the standard deduction, which means that many people no longer can itemize charitable gifts on their tax return. The CARES Act allows for an above-the-line deduction for cash gifts of up to $300. So if you generally just take the standard deduction and you don't itemize, you can write a $300 check, say to the Libraries Foundation, and you can deduct that $300,000 above the line. So that means you get a deduction for it, even if you're taking the standard deduction. So that was done obviously to encourage people to continue giving and to support the organizations that are helping COVID victims and like the library that are helping to keep us sane during these times. Even my kids are actually reading paper books these days, my teenagers. The CARES Act also increases the income limit on charitable contributions of cash. Generally, you can only deduct cash gifts up to 60% of your income. So for example, let's say that you give $100,000 to charity, but your actual income for the year is $100,000. You can only deduct $60,000 of that gift. Now you can carry forward the remaining $40,000 deduction into future years for as many as 5 years. But this year you could deduct the entire $100,000, and there's not a limit. So if you are earning $500,000, you could give up to $500,000 in cash and be able to deduct the whole thing this year. One point to note, since we're discussing charitable gifts, a lot of people funded donor advised funds in 2018 and 2019 in response to the Tax Cuts and Jobs Act and strong market performance. So if you did that, if you do have a donor advised fund that you set up and funded, now's a great, and you've sort of maybe forgotten about it or haven't made any distributions yet and we're waiting for a good time, now is a really good time to put some of that money to work helping the organizations that are addressing the crisis, and again, like the library, those that are helping us get through this. Another provision of the CARES Act suspends the required minimum distributions for this year. So even if you're over 72, you do not have to take a distribution this year. And the goal of that is to avoid having people have to sell assets when they're down at low valuations in order to make their required minimum distributions, their RMDs. Now, to be, again, as a reminder, the Secure Act, prior to the Secure Act, you had to take your required minimum distribution starting at age 70, well, technically starting in April of the year after you turn 70 and a half. That's now, if you turn 70 and a half after January of this year, you have to take it by April after you turn 72. So let's say I turned 72 in September of this year. I could wait until April of next year to take my distribution. my first distribution, but then I still have to take my distribution for next year too. So I end up having to take 2 distributions in the same year, which could be a pretty big tax hit. So generally, unless somebody, maybe I were working this year and I were going to retire next year, then it might make sense for me to have both of those come in the same year. But generally, you might as well just take it in the year that you turn 72. But it's not like, right. I saw somebody had asked a question. It's not right when you turn 72. It's that year that you turn 72. As I mentioned, the CARES Act covers a lot more than that. If you really want to get into the weeds, you can go to the Treasury's website. They've got pretty detailed information on what that act covers. I've talked about some specific considerations for financial planning given current events. One thing I always pester my clients about is having updated estate planning documents signed and in place. And that's, unfortunately, that is something that I really am reminding people of that and that people are thinking of, as Brian mentioned at the beginning. So on that note, I'm going to turn it over to Tiffany, and she's going to give us some pointers on estate planning.
Thanks, Catherine. So in terms of kind of the foundational estate planning documents, we're going to talk a little bit about durable powers of attorney, as well as wills and revocable trusts. That's kind of the trifecta of the common and commonly utilized foundational plans. But first, a little break from all the seriousness with this cat in his lawyer's office saying that he needs a will prepared, and because he has 9 lives, he needs 9 wills. I know you're laughing at home, even though I can't hear you. So what I tell clients and what I tell this cat here is that the durable power of attorney is really, in my mind, the most important piece of the estate planning, the kind of the foundation. And the reason that I say that is it's very important where your assets go after you're gone and making sure that they get into the right hands and that you have things kind of nicely laid out for those that you love. But in terms of the durable power of attorney, this is a document that it comes into existence while you're still living. And we're going to talk a little bit about kind of what's required for the valid execution, because as Brian pointed out, Google searches on how to make a will are up 50%. So folks are kind of DIYing, do it yourselfing, but also a lot of my clients are having to sign outside my office right now because, as you can see, I'm in the guest room at my house. I'm not at my office. And so grabbing a neighbor or other person to help has been really important. And so I've been sending out a lot of documents with various sticky notes and flags, making sure that folks can get their document signed even in these circumstances. So under the kind of what's required to validly execute the durable power of attorney, it has to be signed, it needs to be dated, and it can either be acknowledged before a notary or you can sign before 2 competent witnesses. The key here, and we'll talk a little bit about this with wills as well, is being in the presence of the principal and signing at that principal's request. So the person who's making the durable power of attorney, seeing them sign, being in their actual physical presence, and then signing as a witness there as well. So kind of getting back to the substance of the durable power of attorney, again, this is, I think, the most important piece because it comes into play while you're still living. And what we're doing with these documents is really kind of, to use a baseball reference, we're putting someone on deck, so to speak, to be able to serve as an agent for the person who is executing the power of attorney in the event that that person is unable to, or incapacitated, unable to act for themselves. And a lot of times folks think about, you may have heard of powers of attorney, like sometimes you'll have a document that if someone is abroad and needs to close a real estate transaction, they'll sign a power of attorney that appoints someone specific here in the States to be able to close that real estate transaction. It's very limited to that particular transaction. Durable powers of attorney have that word durable in them. And what that means in kind of the estate planning context, and why you want it to be durable, is because you want it to remain in effect even in the event you lose capacity. Because that's really when you want that person who's on deck for you to be able to step in and act, is after you've lost capacity. And so what we do here is we can name an individual or a professional fiduciary or co-fiduciaries, depending on the circumstances. And we appoint someone to serve in the capacity for finances. So that person is able to manage kind of your financial and kind of affairs, so to speak. They're able to make sure that your mortgage is paid, write checks, for your bills, ensure that your income tax return is timely filed and taxes are paid, talk with your financial advisor, ensure that there's someone in place to be able to make sure that your financial affairs carry on appropriately in the event that you are laid up for a season or for long term. And sometimes we think about the more long-term circumstances where maybe we've had, probably most people who are on this call have had a family member be affected by Alzheimer's or dementia. We're living a lot longer now, and these things, both sides of my family, this is something that, we're going through and that we're affected by. And so oftentimes folks will think about kind of that longer term where someone might need a little bit of help, and then kind of increasingly some additional help for a more long term. And so you want to have someone both on the financial side as well as on the healthcare side. And that can be the same person. It can be two different people. Sometimes folks say, oh, you know what, my son is really, he has a medical background and he's, very pragmatic, and he would be really great in terms of serving as my agent for healthcare, whereas my daughter has a financial background or is more kind of organizationally, her brain works kind of more along that line. And so maybe that's a better fit for the agent for finances. So you can have two different people, you can have the same person, or like I say, you could have a professional fiduciary serve in that role. Just depends on what makes sense for you personally. And so with that, you kind of make sure that those bases are covered, so to speak, that you have someone in place. And then in the event that something occurs, either short term or longer term, that person can step in and act on your behalf, just in the same way that you would on the medical side. Again, talking to healthcare providers, ensuring that the information is received between patient and provider in the same way that you would receive that information if you had the ability and the capacity at that time. The other piece that comes up with the healthcare agent and that part of the durable power of attorney is end of life care. And so I always tell clients, we can talk all day long about all the things that could happen, to our physical bodies and still not think of everything. And so having kind of some broad language available for that person who's on deck to act in the event that, unanticipated circumstances arise, because they're never anticipated. Just to ensure that your values are communicated to that person in advance when you're signing that document, and that person is basically set up for success to know what you would want in terms of end of life care if that was a decision that had to be made. Would you want life support, things like that. And one note about this is, and then we can kind of shift into discussion of wills, is I think that is kind of odd as it feels to have that conversation. In my own life, we lost my stepmom. She was 55, so she was very young. And my dad had to make that decision. And the very small sliver of kind of a silver lining, if you will, is that they'd had a lot of conversations about that. And my dad knew what she wanted, what my stepmom wanted. And so, as hard as that is, putting someone, kind of giving them the information and setting them up for success in those circumstances is really, I think, a really good gift that you can give to those that you love. So next, we're going to kind of transition into talking a little bit about wills.
Can I jump in? Sorry, can I jump in and interject for just a minute?
Absolutely.
One thing that I really want to note on that power of attorney, as a financial advisor who helps people deal with accessing money in their accounts, I can't tell you how important it is to have that document and have it done correctly, have it signed by the witnesses, have it notarized, do it exactly as it's supposed to be done. Because if you do run into troubles, or more likely make sure that whomever your parent or an older sibling, make sure that it's all done correctly, because assets can end up being tied up in the account if the DPOA is not executed correctly and the custodian can't accept it. You'll have trouble getting the courts to name whoever to. It just is a hassle. So make sure that those documents are done and done correctly. One note on the healthcare, particularly on the healthcare power of attorney, but on the financial too, if you have teenagers who are away at college, my husband and I have two who are in college right now. They're home right now. And while they're home, we need to get them to sign powers of attorney, both for finances and healthcare. Because technically once they turn 18, you as the parent don't necessarily have the right to know everything, to make decisions. I did see a question come through that is your DPOA financially liable for your healthcare expenses? And the answer is no. They are making decisions for you, but they are not liable for any of your, they are not personally liable for any of your expenses. And you don't have to name that person on your checking account. The DPOA, once that's filed with your banking institution, whoever's power of attorney will have the rights to that account. You don't need to have them named on the account. So sorry for the interruption, but just a little real world, just encouraging people to do that, because it makes things so much easier when it's done correctly. And you may need that more than you think you will. Also, another point of clarification I see people confused about a lot is that the DPOA is in effect until you die. The minute you die, that DPOA is no longer in effect, and your will and your estate plan immediately take over. So whoever's named as your executor or your personal representative is then going forward responsible for your accounts. The DPOA does not carry through after you die.
Thanks, Catherine. That's helpful. And I see another question that just popped up that you might want to answer. Do we need to register DPOA with all financial institutions, 401k, banks, etc.? In my end, go ahead and hop in there, because you see this.
Yeah, you don't need to do it in advance. If you're healthy right now, you may. Generally, what we have clients do is they'll give us their power of attorney, so we have it on file, and then we'll take care of getting it to the custodian. So you can do that, but really the person who has power of attorney is the one, once it's triggered, that would be giving it to all of those different institutions and saying, I have power of attorney now, here's the documentation for that. And often institutions will have some of their own forms too that have to be completed. It differs by institution.
That's one thing that I've come across a lot, is differing between institutions. And some banks will say, we want this to be notarized and have two witnesses. And so if you have the opportunity to talk with your financial institutions to see if there's something specific that they want in addition to the validly executed document, then be sure to do that, because it makes it just that much easier for your agent. And one other point that Catherine raised that I wanted to add something to is regarding do you have to add the agent under power of attorney? Do you have to add that person to your checking account? And that's a question that comes up a lot. Again, as Catherine said, no, the answer is no, that once that power of attorney is, on file or recognized by the financial institution, then the agent will have the ability to make transactions for your benefit. But very important, I see this a lot, as Cindy mentioned when she was talking about what I spend my time doing. A lot of my practice is related to trust and estate litigation. And so I see when things have gone awry or when things have not been planned for. And sometimes folks will add, they have 3 kids and one lives nearby. So they say, oh, well, I'll add that child to my bank account so that they can help me if I need them to write checks, which makes sense but oftentimes they'll unintentionally or inadvertently make that person an owner on their account. And then when they die, that asset goes directly to the person, the one child that they named on their account, rather than all three, which is probably oftentimes we see this when that was what was intended. And so rather than going around and adding folks to bank accounts, having your power of attorney in place and properly and validly executed is really the best step that you can take in order to have someone set up to assist if you need it. So moving into the requirements for a validly executed will, wills kind of we've got a couple more foundational tools to talk about: wills and revocable trusts. And for wills, you need to have a writing, and I've included that because there are some funny cases that are very old where someone kind of carved something into a seashell or wrote something with a stick on the beach. So is that a writing? Well, it was considered a writing, but when high tide comes, then their will's gone. But so we write our wills on paper if possible. So it needs to be written, and then it needs to be signed by the testator. So if I'm making my will for myself, then I'm the testator. I have to sign, and then it needs to be signed by 2 or more competent witnesses, also in the presence of that testator. And so one thing that we've seen in the legal community coming up around this stay home order and all of us kind of having to social distance is, well, what does in the presence mean? Can I watch my client sign their estate planning documents via Zoom and then serve as a witness? And at this point, the answer is no. That's not physical presence. And so that's something to be careful of when you're, if you are doing something yourself, or if you are signing your documents, that your attorney prepared, and you have your witnesses, but you say, yeah, I don't really want them to, come over or be on my porch. I'd rather just do it via Zoom. It's not technically under the statute. It doesn't meet the standard of in the presence of. So sign on the porch, sign in the garage with the doors open 6 feet apart. That's all fine, but just make sure that they're signing in your presence. So in terms of kind of what the this is a picture of me and my husband serving as witnesses for a neighbor, a friend in our neighborhood to their will. So he picked cowboy and I picked bandit that day. So in terms of kind of what the will does, what that is, and a lot of you have probably either executed one or at least heard of them, is this is the document that as Catherine mentioned, your durable power of attorney is valid until you die. So at the moment that you breathe your last breath, that's when your durable power of attorney is no longer the governing document. And then your will or the intestacy statutes or a revocable trust, as we'll talk about, becomes kind of the roadmap, so to speak, as to where your assets go. So wills are not effective until your death. You can change them anytime during your lifetime, presuming that you have capacity to do so. And basically, this provides a roadmap for distribution of assets. You appoint your executor or your personal representative, who's the person that is charged with basically gathering all the assets, paying all your creditors, filing final income taxes, things like that, selling real estate, liquidating assets if necessary, and then distributing those assets according to the roadmap that you've set up, either to your human beneficiaries or trusts for certain beneficiaries, charitable organizations like the King County Library System and the Seattle Public Library Foundation. So this is where you name all those folks. And one thing that folks think about in terms of, well, do I want to use a will or do I want to use a revocable living trust as my primary planning tool, is we get into a little bit of a space of avoiding probate, so to speak. Now with a will, or if you do absolutely nothing, then you fall under the Washington intestacy statutes, meaning Washington has gone ahead and laid out a roadmap for you in the event that you don't lay one out for yourself as to where your assets will go. But under a will or the intestacy statutes, your estate will go through probate. And in Washington, that's not quite the dirty word, so to speak, or the nightmare that it can be in some other states. Because what that is a court supervised process of gathering the assets, paying creditors, filing income tax returns, making sure that all of the deceased person's final affairs are buttoned up, and then making distributions for that person according to the roadmap. And in some states, like California, for example, um, probate has a really bad rep, with good reason. It's expensive there. The court system is clogged. It takes a very long time. Whereas Washington, it's not that way. In Washington, you pay your $240 filing fee and you're off to the races. And what that looks like is, you file the will with the court, and then, like I say, you pay that $240 filing fee. This is all things that occur after death. So the person who's the executor files the will with the court, pays the filing fee, and then the court says, yes, you are the executor. You have the authority to manage Tiffany's assets and make final distributions. And that's really kind of one of the differences between wills and revocable living trusts, which is on the next slide, is this type of a document, a revocable trust, is going to be active during your lifetime. It's something that, you execute it and you transfer title of assets to the name of the trust. So that's different from a will, because with wills, you just kind of write out the roadmap, execute it, and then things happen after death. That's when it becomes kind of activated, so to speak. Whereas with a revocable trust, you change title to your assets during life. So if I were executing a revocable trust, I would say, okay, I don't own this house as Tiffany Gorton anymore. I now own it as Tiffany Gorton, the trustee of the Tiffany Gorton Trust. So you just change title a little bit. You still pay your mortgage. You still pay your taxes. You still do all those types of things as you normally would. This is not a tax savings vehicle, which is a common misconception. There are some trusts, many trusts, that are tax savings vehicles, but the revocable trust is not one of them. You would still pay your income taxes the same way that you currently do. You still pay property taxes the same way. You would still, any assets in the revocable trust would be subject to the estate tax after death if it rose to that threshold level. But what it does do is a probate avoidance tool. It also can offer some privacy for clients. So when I'm having a conversation with someone and they say, I need a revocable trust, or oftentimes they'll say, hey, I read this thing from Susie Orman and I need a revocable trust. She's a huge proponent of revocable trusts. I don't know if she's from California, but when folks say that to me, I say, well, let's talk a little bit about that. Because when I am going to recommend that someone use this as the tool, there's usually just a couple of scenarios where this comes up. And so if folks have real estate, like out-of-state real estate, so they have a place in Idaho or Oregon, or anywhere that's not Washington, then it might be at least worth talking about utilizing a revocable trust as opposed to a will to avoid having a probate in Oregon and a probate in Washington and in Idaho and in all the places that they own real estate. Because with a revocable trust, you can title each of those properties in the name of the trust during life, and then no probate process is required in any of those states. So that's one attractive piece about a revocable trust. The other is the other circumstances that sometimes comes up is if folks say, you know what, I want some privacy. Wills are filed with the court after someone dies, and they essentially become sort of a public record. Now, I don't know how many people are trolling the King County or any other county for that matter court website to look at people's wills, but they're very uninteresting. They are just a list of beneficiaries and how things are going to pass to them. It doesn't include social security numbers. It doesn't include bank account numbers, things like that. If you do have to reference an account, we'll put, last four digits or some other identifier for that account, but they are public. And sometimes people feel a little uncomfortable with that. And they say, you know what, I'd prefer not to do that. Whereas with a trust, only the trustee and the beneficiaries have access to that document, not, anyone on the King County Superior Court website. So that's one reason. And where that kind of comes into play is sometimes folks will say, I have one child or a niece or a nephew or some family member that likes to stir things up. I think we've all got one. anyhow, if you think someone might come along after the fact, after you're gone, and make trouble, oh, Tiffany, remember, she meant to include me there, she just must have made a mistake, comes along and wants to either contest your documents or otherwise harass your beneficiaries, that could be a reason sometimes not having a public document as kind of the governing tool like a will would be, is sometimes attractive to folks if those circumstances exist. So it's really very few that it makes sense. And sometimes folks say, I'm just more familiar with it because my parents had it, or I've dealt with it before, and so that's the tool of my choice, which is totally fine. But the bottom line is, for most Washingtonians, a will is going to be more than sufficient in terms of a planning document. And it doesn't matter big or small size of the assets that are in the estate. It's not a $500 Buick in a base fiddle estate versus I got $1 billion, so to speak. That is not going to really be kind of the justifier either way, or the deciding factor, so to speak. So we talked a little bit about what probate is. It's that court supervised process that allows the personal representative or the executor to manage the deceased person's assets, gather them all up, pay all the creditors. And one of the things to think about in terms of probate is kind of what's not a probate asset. And this is important. Catherine and I actually have a shared client where someone had a non-probate, what would have been a non-probate asset, an investment or a retirement account, and no beneficiary was designated. So as a result, we're in a position of that sizable account having to flow through probate, flow through the estate to go to the beneficiaries under the terms of the decedent's will. So non-probate assets are typically retirement accounts, assets, bank accounts, financial accounts that you can name a joint tenant with rights of survivorship. Property that's held in a trust is going to be non-probate. Life insurance policies, and particularly those life insurance policies, financial accounts, investment accounts, retirement accounts. Think about those things because they all have a beneficiary designation associated with them. They all have a contract of their own associated, and thereby kind of are a non-probate asset if they're appropriately filled out. And as Catherine can attest, making sure that your beneficiary designations are current and of your intent and completed is really important. And it's also very easy. You don't have to get a notary. You don't have to, sign before a witness. You just have to include the person that you want to receive those assets on the account after death. And this is something that's important in terms of estate planning, because what you want to make sure to do is have those assets mirror what your estate plan says. So avoid the kind of potential pitfall of saying, oh, I have my oldest child listed on all my accounts, but I have 3 kids now and they're included under the terms of my will. But because the oldest child is the only beneficiary designated, the oldest child is going to get those accounts. So make sure that your beneficiary designations are current and reflect your current intentions, and make sure that they're completed to avoid them having to go, through your estate for no particular reason.
And I will say that, I'll jump in and interrupt again, that when the beneficiary designations are done, that when we've got them recorded and they're on file, it's really easy to distribute the IRA. Either we set up a spousal IRA, or it goes into, if you're leaving it to your kids, inherited IRAs, and it's really easy for the financial institution to do that. They just need a copy of the death certificate, and they set up accounts for the folks inheriting the IRAs, and the assets roll over, and it's pretty straightforward. If you do not have that done and you don't have any beneficiaries designated, you run into what Tiffany and I are running into with the client that she mentioned, where it's got to go into an IRA that's owned by the estate. In this case, there was a trust set up through a testamentary trust, so there's a trust in the will. So now it's going to have to, the assets are going to have to go from the estate into the trust, and then out to the kids. Hopefully we can figure out how to get those assets, those distributions, taxed when they're to the kids, because the kids are going to have a much lower tax bracket than the estate or the trust if that's not done correctly and they end up being taxed to the trust or the estate, there's going to be a lot of money left there. Additionally, Tiffany's having to get involved, and we'll have to get a CPA involved. And Tiffany's awesome, but it's more expense when you haven't done it correctly, and it's got to be cleaned up on the back end. So a lot of people put off taking care of these things because they don't want to pay the money for an attorney right now, or they just can't bring themselves to, they can't make a decision. That's what happened in the case of our mutual client. He could not make a decision on who he wanted, so he just didn't name anybody. And now, unfortunately, there's more money is going to go to taxes, attorneys, and accountants than would have had he just made his decision and signed the beneficiary designation. So again, just real world experience that please do that, because it's so, and that's such an easy thing to change to later. So if you're not sure, just put who you think you want to do it, and then you can change it later, because it's really easy. Because as Tiffany noted, you don't have to have that notarized. You don't have to go to an attorney to get it changed. You just fill out a new form with the institution.
All right, thanks. I wanted to make one more point regarding kind of one of the pieces about wills before we moved on to a brief kind of tax discussion. And that is that one thing that folks will oftentimes be prompted to think about their estate planning, besides, you know, being home, is thinking about their minor children, or, you know, providing for a surviving spouse. And the will and your durable power of attorney for those with minor children, those are the places where you would name a guardian. And that's something that is really important for families with minors, is ensuring that you have someone in place that would, you know, serve as the guardian for children. And also you can include testamentary trust language. And what testamentary trust language is language in a will that sets up a trust later after you're deceased, to ensure that either your surviving spouse is cared for, there's some tax planning that you can do there, or ensuring that your minor beneficiaries, like I was talking about a little bit earlier with the conduit trust and the accumulation trust, when you're thinking about having minor beneficiaries inheriting and wanting to kind of protect them from themselves, including some language in your will as testamentary trust language can really support. It's an opportunity to really support minors, other beneficiaries who perhaps should have some oversight or otherwise. So kind of with that, I want to transition and talk just for a minute, just kind of about the estate tax. So our friend Benjamin Franklin said it, in this world, nothing can be certain but death and taxes. So we've talked about death. Now we're going to talk a little bit about taxes. So the estate tax, again, this is different than income taxes, different than real property taxes. This is a one-time transfer tax, and this happens after the person is deceased. So I won't ever pay estate taxes on my own estate. And typically, if you have a surviving spouse, any assets that are going to go to that surviving spouse are going to qualify either to them directly as a beneficiary outright, or through another planning tool like a trust, or otherwise. Those tools, any assets that go to your surviving spouse qualify for the unlimited marital deduction. So oftentimes this is a tax that does not come into play until both spouses, if you have a spouse, are gone. In Washington, we have our own estate tax, and the exemption amount is $2,193,000. I mentioned just a minute ago that utilizing language in your will or in your revocable trust, for that matter, you can utilize some language to do some tax planning. And one easy way to kind of double the Washington estate tax exemption amount, meaning you don't have to pay tax unless it rises to $2,193,000. We'll call it $2 million for ease of conversation. But kind of doubling that is to provide a credit shelter trust for a surviving spouse. And so then instead of having just the $2 million, you're effectively protecting, shielding $4 million from estate taxes in Washington. At the federal level, the estate tax exemption is over 11 million, $11,580,000 per person. And that is there's something called portability at the federal level, and so spouses, married couples, can double that to 23,000 essentially. So I don't have an estate tax problem. I'm hoping to get there. I'm working on it. But one thing to think about is that, these numbers are only as good as, the laws in effect, and so these do change. And as we saw, a significant spike at the federal level in the exemption amount, that is set to sunset in 2025. So there's, likely to be back to the 5.5 million before. But importantly is, for Washingtonians, is the Washington estate tax, because the exemption amount is a lot. $2 million is a lot to Tiffany Gorton. But in terms of, if you have a house in King County, maybe a retirement account, your assets can add up quicker than you would think, to get to that threshold of at least filing and reporting. So, and one thing to note regarding kind of just these two slides here show the way that the estate tax is applied. And so basically, if you reach that threshold level, then between 10 and 20% for Washington state, and between 18% and 40%, depending on how the size of your estate. That is kind of how the tax is going to be calculated. And so, at the top level at the feds, 40% is a significant amount. And the amounts in that bracket, you can get there pretty quickly, so it seems, as you can see from this slide. So with that, Catherine, unless you have anything to add on the estate tax, I think we can take a few questions.
No, I think we're good for some questions.
Okay, we have a question from Mark, and this one I believe is for Catherine. And it's, the required minimum distribution begins at age 72. Or does it begin at age 72, or does it begin in the year one reaches age 72?
It begins in the year that you reach 72. It's not right at, you don't have to take it on your birthday. And as I had mentioned before, technically it's April after the year in which you turn 72, but for most folks, it makes sense to just go ahead and take it in that year that you turn 72, so you're not doubling up on a distribution and the taxable income in that following year when you're 73.
Great, thank you. And then this question is for Tiffany from Connie. In an accumulation trust, is the age of the beneficiary of the trust an issue?
No, it's not. So that's the type of trust that, if there is, basically the asset can remain there and the trustee does not have to make those distributions over the 10-year period. The issue becomes the income tax on those accumulated distributions inside of that trust, but the age is not a factor. And so that's something that when you're weighing like minor beneficiaries, for example, or young people, and you say, oh, I don't really want them to start getting these assets until they're 30 or 35 or a little bit older, thinking about including accumulation trust language. Again, there's going to be a tax effect or tax impact, but it's something that when you're thinking about who your people are and who your beneficiaries are and how they really should have things managed for them, that's something to consider.
Thank you. And then a question from Kim for Catherine with regard to the CARES Act and the $300 above line charitable deduction. Does it need to be all to one entity, or can it be $100 to 3 different organizations?
It doesn't need to all be to one entity. It's $300 total to different charitable organizations.
Great, thank you. And here's a question from Raquel about DPOAs. For financial purposes, would the person need to be on your checking and your savings account, or does a durable power of attorney take precedence?
So the durable power of attorney would take precedence. You don't need to add that individual to your checking or savings account in order for them to be able to assist you or manage finances, step in and help. The durable power of attorney kind of is a blanket for all of your assets. And by actually adding someone to your checking account or savings account, you can have that unintended effect of making them like a joint tenant meaning that they're kind of a co-owner, so to speak, and that's not always intended. So just having your power of attorney properly executed, you don't need to take any additional steps in terms of adding folks to accounts.
Thanks, Tiffany. And as a follow-up to that, can your durable power of attorney also be your executor?
Absolutely. And sometimes that makes perfect sense. You have a certain family member or, professional fiduciary that you want them to serve during your lifetime as your agent. And then when you're gone, your will kicks in, so to speak, and they can serve as your executor. And oftentimes that's the most natural fit, because that person may have some familiarity having served as your agent under power of attorney during your lifetime, some familiarity with your assets.
Great, thanks, Tiffany. And this next question is from Elizabeth, probably for Catherine. Does a 403B or 457 work the same as an IRA when you die, for example, with the 10-year stretch?
The 403B, which is essentially the not-for-profit version of a 401k. So if you worked for the city, you'd have a 403B, whereas if you work for Amazon, you'd have a 401k. It's all retirement accounts. I was bad about using IRA because it's a nice, easy, short handle for it, but it's all retirement accounts. Now the 457 is different. That's a deferred comp account. And that is handled differently. There's generally not a stretch for that. And a lot of the 457 is going to depend on the institution that is the employer and how the employer wants to handle that. But it's different from the 401ks and the 403bs, which have more protections around them and a little bit more flexibility. So you need to check with the institution and see what their options are for the beneficiaries. One point that I forgot to mention with somebody had asked if you have the same problem if you name your estate as the beneficiary of your IRA, is that the same problem as if you hadn't named anybody? And it can be a little more straightforward if you're doing it on purpose. If that's what you want to have happen, you can have it set up that way. But one thing to note is that when the IRA, that's another issue that we're going to have with this client, where the kids could have had, well, actually, he passed away last year, so they could have had stretch IRAs, but now we're going to have it distributed within 5 years, because if an IRA distributes to an estate, it's got to be done or a trust, it's got to be done within 5 years. There's not even a 10-year stretch. So it's generally better not to do it that way, but it's conceivable that there are some estate plans where that wouldn't make sense. And talking with a good attorney like Tiffany is a great idea.
Thanks, Catherine. And Tiffany, with respect to all these documents, are they valid from state to state, or does one need to redo them each time they move?
That's a great question. So the states have different laws. And so while there's some similarities and oftentimes, very close rules about these, it's important to think about if you are moving, like I have a client, for example, who's moving to Oregon, and I'm going to connect them with an Oregon attorney just to double check, make sure that they're not missing something there, because you want to make sure that you avail yourself of the appropriate state's laws. So is it going to be invalid? Not necessarily, but you want to make sure that what you have comports with what the state requires. And we see that a lot, specifically like with trusts, where someone will come from California, for example, and they have a trust there, and it's just a matter of kind of amending and restating that trust so that it comports with Washington law. So it's oftentimes more efficient or cost effective for an attorney to basically kind of draft about the same kind of process documents in the new state than to try and go through and tick and tie everything from someone else's work. But at the end of the day, making sure that you have at least someone take a look to ensure that you haven't missed something for that state is really important.
And especially if you're moving from someplace like Washington, where probate's pretty straightforward, to someplace like California or Hawaii, where it's a nightmare, and most estate planning attorneys in Hawaii will tell you to do a revocable trust. and to put your assets into a revocable trust. So especially if you're going from a state with easy probate to one where trusts are better, it might be a good idea to have that all redone.
Thanks to you both. We have time for one last question, and that question is from Angela, who asks, what do you do if you own assets outside of the country?
That's a great question. And the answer is it depends. That's one of our favorite responses as lawyers. It's important to look at all countries treat things a little bit differently. And so depending on what the asset is, if it's a financial asset or if it's real property, real estate, and what the country is that you own it in. I'll give you an example. I have a client who is originally from Australia, and she has a financial and investment account there. And so I contacted local counsel to say, hey, do you have the equivalent of a beneficiary designation in Australia for this account? They had no idea what I was talking about. So it's very different. So there, her will here is going to be valid there, but they require an original. So when she dies, does the original get filed with the Washington, the King County Superior Court, or get shipped off to Auckland so that they can make distributions for that account? So making sure that you get someone involved that knows a little bit of something or can at least reach out to local counsel is important, because you want to make sure that what you have here in the US, what you have in Washington, is either going to govern the asset that you have in the other country, or make sure that working with local counsel there, that you take whatever steps you need to do in order to ensure that that asset's going to transfer appropriately.
Great, thank you, Tiffany. And I'm going to turn it back over to Brian for our last minute details.
Well, again, our sincere thanks to Catherine Haggett-Fisher from Fulcrum Capital and to Tiffany Gordon from KHBB Law for taking their time out of their schedules to share this information with us and these ideas for all of you. We certainly hope that you found it valuable. And I just want to remind you that their information is posted on the screen, and we are going to send out a follow-up email after this, so you'll have their contact information. The only thing we ask is you just be a bit patient with the time that it might take them to reply to you. They are wonderful volunteers to our organizations, and they volunteered their time today. So again, we just ask that you be patient as they work around the schedules of their paying clients, et cetera. So, and again, thanks to all of you for being part of our first virtual event sponsored by both the Seattle Public Library Foundation and the King County Library System Foundation. We are organizations that are supported by donors. Many of you are in this room are supporters of our organization. And I want to remind you that, a charitable bequest is one of the most meaningful ways that you can support the nonprofits that you love, including the library. So there are some wonderful attorneys that can help you, and we'd be happy to provide a list of attorneys that our organizations have worked in the past. There are also online resources, like our library is going to be rolling out something called Free Will in the next 2 weeks to help people start beginning to plan their estates. But of course, legal advice from a professional like Catherine or Tiffany is always the way to go. So if you have any questions or like to continue this conversation, my information is on the slide deck here, Cindy's information as well. And then Kara McDonald is also our Director of Major and Playing Gifts at Seattle Public Library Foundation. You can simply just reply to the registration email that you received, and we'll get you connected with the person that can help you with any of your information needs. So again, look for a packet from us with copies of the slide deck, a quick survey about this experience. Again, our apologies to all of you who accidentally didn't see the update about the Zoom meeting, the Teams to Zoom conversion. We did that to increase the number of participants that could take part in this. So we appreciate your flexibility. So thank you, and we look forward to continuing this conversation, and hope you all have a wonderful, wonderful evening.